we are going to be looking at the remedies available to judgment creditors. Remedies available to judgment creditors. So, first of all, we need to find out who a judgment creditor is. A judgment creditor can be defined in various ways, but in the end, we sum it up by saying that a judgment creditor is a person in whose favor judgment has been given. But in a strict sense, a judgment creditor means somebody in whose favor a judgment has been given in a monetary judgment. In other words, he is a person in whose favor the court has ordered that a particular amount of money be paid to him or to her or to it, assuming is an official person. So that is who a judgment creditor is. And then again, a judgment creditor can also be somebody in what we call a declaratory judgment. Judgment has been given in favor of him, but that judgment is declaratory, but the judge made pronouncements concerning award of damages in his favor because he needs to recover the money. Or even if what the court awarded was just cost, he's entitled to recover the cost awarded in his favor. So to that end, therefore, he is qualified to answer a judgment creditor. Now, we also need to know that to say judgment creditor does not mean that is in every case where money has been awarded before somebody can be termed a judgment creditor. No. A judgment creditor can also loosely be referred to as anybody who has won a case, anybody in whose favor the judgment of court has been entered and the judgment is subsisting in his favor. He is loosely called a judgment creditor, while the other party, the party that lost out in the matter, is referred to as the judgment debtor. So we also need to look at then what are the remedies available to a judgment creditor. That is, that person who has won the case in court. What are the remedies available to such a person? What and what is that person expected to do? As a matter of fact, somebody who went to court for a reason, and maybe it could be to defend his right, to claim his right. So if it goes in his favor, he needs to do something as someone in whose favor judgment has been given. All right. So we're going to be looking at those things that somebody who won a case is supposed to do. That is the judgment creditor. Those things that he is expected or he is supposed to do. Now, it depends on the type of judgment given in his favor. In other words, he needs to enforce the judgment in his favor. So for the purposes of enforcement, judgment can be categorized into enforceable and non-enforceable judgments. So when we talk about enforceable judgment, it simply means that judgment that the person in whose favor it has been given can put it into effect, can rely on the pronouncement of the court, which in enforceable judgments are mandatory. They mandate somebody to do something. They compel the other party to do something. So this person in whose favor the judgment has been given, we have the right to enforce it if it's an enforceable judgment. In other words, If, for instance, the judgment has said that Mr. A is indebted to Mr. A to the sum of, let's say, 1 million naira, and the same judgment may give time limit for that amount to be paid to the person who has won the case, that's Mr. A. Now, once that time accrues and there is no appeal against it, Mr. A will take steps to ensure that he does what? He recovers that money that the court has awarded in his favor, be it a contract sum, be it damages or cost of action awarded in his favor. Now, again, an enforceable judgment can be informed that mandates someone to return. Maybe somebody unlawfully seized your property and you went to court, and after hearing, the court gave judgment in your favor, mandating that person either forthwith or within a week or within a specified time to return that chattel to you. Now, when that time comes up, you will take a step to ensure that you do what? You recover it, because it is an enforceable judgment. Similarly, if you are a landlord and you have taken up your tenant for eviction purposes, and at the end of the trial, the court orders or ordered that defendant to vacate the property within a stipulated time. If within that stipulated time the defendant does not vacate the property, you take steps in the absence of any subsequent appeal. You take steps to do what? To ensure that that defendant leaves your property. If he was owing you arrears of rent, you also take steps to ensure that those arrears of rent are paid to you. We're talking about judgments that are enforceable. They're enforceable. Now, there are also some other types of judgments that are not enforceable. That they are not enforceable does not mean they are not judgments of the court. Yeah, they are judgments of the court, but they are not the kind of judgment that you can take or invoke the coercive instruments of the court to go and enforce them, just like enforce a tenant, enforce a judgment against a tenant by throwing the tenant out of the house, moving his property to the court, clearing the place. Not the kind of judgment that you may destroy somebody's property to sell it in order to recover damages awarded in your favor, or to recover a contract sum that is owing you, or it might as well be money hard and received. But in this kind of situation, a court has given a judgment, but that judgment simply pronounced on a state of being, a state of fact. Maybe saying, I declare Mr. A as the rightful son of Mr. B and stop simpliciter. You don't enforce that kind of a judgment. What it has done is to do what? To give him, to recognize his right, a bundle of rights. And then after that, that right is in escrow, except maybe some other thing is done to activate it, assuming this person declared the first son, now wants to take his position or to perform some certain duties as the first son of the man, and then somebody somewhere is hindering him. Then he can rely on that judgment as in order to commence a fresh course of action. So we're also going to look at some of those things he can do. And then in this regard, therefore, I just want to look at the meaning of execution. I've been using the word enforceable, non-enforceable. In other words, we simply mean judgment that can be is capable of being executed, and judgment that are incapable or being executed. What then is the meaning of execution? Execution, in the words of Lord Denning, in the case of Re Overseas Engineering, Great Britain Limited, I take the case again, Re Overseas Engineering, Great Britain Limited, 1963, Chancery, page 24 at pages 39 and 40. The master of the rolls in that very case defined execution as meaning simply the process for enforcing or giving effect to the judgment, giving effect to the judgment in case when execution was heard by means of common law, by means of common law writ, such as fieri fecere. I'm going to explain that. It was legal execution when it was heard by means of an equitable remedy, such as the appointment of a receiver, then it was equitable execution because it was a process of enforcing or giving effect to the judgment of the court. Now, what you need to take home here from this quotation simply means execution is something as enforcing the judgment. It simply means making sure that you are taking advantage of the judgment given in your favor. If the judgment has said that so house belongs to you, it means how do I get the house back? That is enforcement. If the judgment says maybe the child in dispute is your child, then how do I execute the judgment? How do I enforce the judgment? So you look at it and take steps. As when we're looking at the remedies, we're going to be talking about those things you can do. In other words, the first thing, the first remedy a judgment creditor thinks of is to do what? Is to enforce the judgment in his favor, to execute the judgment in his favor. And then when talking about execution, he will ask himself, this judgment I'm talking about now, is it a kind of judgment that is capable of being enforced, a kind of judgment that is incapable of being enforced? Now, for the purposes of execution and enforcement of judgments, judgments are divided into two categories. The first category is what we call declaratory judgment, while the second one is what we call executory judgment. In declaratory judgment, it simply means that kind of judgment where the court has made a pronouncement as to the state of being. Simply like answering a question, do I have right to do this? And the court said, you have right to do it. But the court has not said, do it tomorrow or next tomorrow. So, in other words, the court simply defines your right, simply tells you this is the situation of things, but the court has not empowered you to do any particular thing. I still go by that early example. If, for instance, paternity is an issue, and maybe someone has sued for a declaration that he is the son of Mr. A, and maybe after the trial, the DNA test and whatever, the court finds out that actually this person is the son of Mr. A. Now, depending on what the claim in the suit is all about, once the court makes declaration that it is hereby declared that B is the son or daughter of Mr. C, simplicity, without making any other statement, then that is a declaratory judgment. It cannot be enforced. But if maybe in drafting that suit, your lawyer has stated, the first one, a declaration calling upon the court, a declaration that the claimant is the son of the first defendant. Two, a declaration that the claimant, being the son of the first defendant, is entitled to move into the house of the first defendant and live with the same first defendant as a family member. Two things are involved here now. If the court declares that yes, A is the son of Mr. B, and then also declares that having found that A is the son of Mr. B, it is hereby ordered, that is compulsion now, that is a mandatory order now, that the claimant is hereby granted the right to move into the house of the first defendant to live with them as a family member. The first arm of that judgment is declaratory and is non-enforceable because it simply talks about rights implicita. But the second arm is an order. So it's executory. It has told you to take a step. So once the judgment says, do this, or this has to be done for you, that kind of judgment becomes what? Executory. So you can have a judgment, one judgment, a portion of it being enforceable, another portion of it being enforceable. It's very, very possible. Again, too, let's say, for instance, someone has taken an action filed an action in court for a declaration of title to a particular piece of land. One, claim two, a declaration that the act of farming on the land forcefully by Mr. B amounts to an act of trespass. C, sum of 20 million naira as damages against Mr. B or C for entering, for unlawfully trespassing into the land of the claimant. If all these claims succeed, it is covered that the first one will be a declaratory judgment, is a part. In that judgment, now you see the first part, the court declares that from the evidence before me, the court is convinced that the claimant has proved his case on the balance of probabilities. And the court hereby declares that the claimant is the person entitled to the piece of land known as and called dash 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 situated as this. That's a declaratory judgment. You have won. That is your right. The court has said you have a right. But then the second one, the court also declares that the act of Mr. B entering into the land of the claimant without the consent of the claimant amounts to trespass. If that is all about the judgment, all you know is that this judgment has given me right. This judgment has said that this man is a trespasser. You can't enforce either of them. Now, but if the C part of it says the court hereby awards a sum of 20,000 naira against the defendant for unlawfully trespassing into the land of the claimant, that one is what? Is enforceable because it is a command, an order, something that can be executed because you need to recover that 20,000 naira as the damages awarded by the court in your favor. Then again, we'll move further. There is a case I want to look at, and this case has to deal with declaratory judgment. Let's see what the court said in the case of government of Gongala State against Tukru. Is a popular case. You also find it in your human rights course. Case of government of Gongola State against Tukru, reported 1989, 4 Nigerian Law Report, part 117, at page 592. Here the Supreme Court said, declaratory judgment simpliciter is a solemn affirmation is a solemn affirmation of a state or status by a court that in itself is a complete relief which is not executory. Is a complete relief which is not executory. Why? Because the court has said this person has this right, and the court has stopped at that. So, which means it's a complete judgment for you. But then there's no way you can execute it. If, for instance, you were in possession of the land when the declaration was made that this land belongs to you, all well and good. You're already in possession. There is nothing again to execute. This other man has been adjudged a trespasser. So if there is no damages given, maybe the court looked at the circumstance and felt maybe it was maybe just a case of maybe either the person, a case of mistake, he thought the land was his own, a case of honest belief, honest mistake, and then in the end there is no damages. That means there is nothing to enforce because that judgment is a complete judgment on itself, and is a judgment in your favor. And we also have to remember that a judgment of the court is enforceable once it's an executive kind of judgment. You can enforce it at anywhere in Nigeria on anybody that is a party to that very case. Then, in support of this decision, we will also look at the case of Okoya and Santilli. Okoya and Santilli is reported in 1990 to Nigerian Weekly Law Report, part 131 at page 172, where the Supreme Court described declaratory judgment as an embodiment of a particular right, an embodiment of a particular right which may be the basis of a subsequent proceedings. It may be the basis of a subsequent proceedings. In other words, you may want to ask me, if declaratory judgment is not enforceable, then of what use is it? That's what the Supreme Court is telling us in Okoye and Santilli. If you have a declaratory judgment in your favor, it has spelled out your rights, it has given you the power, and with that judgment, you can now stand on it as a platform to challenge any other person that will want to enforce into your right. In other words, is your power to now institute another proceeding, assuming someone else maybe comes to trespass into that very land, or somebody challenges you. So if, for instance, because there are instances where declaratory judgment would not be satisfactory enough for the person in whose favor the judgment is given. And then it may be due to how the claim was couched, or the claims were couched. And that is why, in practice, when you couch your claims to spell out declaratory reliefs, you also want to foresee situations where you may want to have benefit that is attached to that very right. And then you also put in some claims that if determined in your favor, they would amount to executory judgment that you can execute. But if not, the only thing you can do is to rely on your declaratory judgment for a subsequent proceeding. Then also again, in some textbooks, you will hear something like interlocutory judgment. Interlocutory judgment. Now, when you hear judgment, like I said, judgment is just like a final judgment on that very issue. But in the actual sense, we may not exactly have anything called interlocutory judgment. So when you hear interlocutory judgment, they are just like that judgment that has not completely determined the right of somebody. It is means that your course of action has been stopped at a particular stage, interlocutory. And this can occur If you had sued somebody and the court declined jurisdiction and strikes out your case, if you stop at that stage, as far as the other party is concerned, he has won. You filed a case against him and it was struck out. So you will need to either proceed to appeal against it or to come back and file your action in the proper court or find out what went wrong in the former suit that was struck out so that you can be able to have a second bite at the cherry. And then the second, like I think I have already explained executory judgment. Now the second relief is contempt proceedings. Remember the first one is execution. It is the execution, your right to execution that led us into talking about is it judgment executory? Is it declaratory in nature? Is it enforceable? Is it unenforceable? It's because of the first remedy. Now we're talking about the second remedy now for the judgment debt creditor. Second remedy for a judgment creditor is that if the judgment of the court is such that compels the person who lost the case to do a particular act and he has failed to do so, you can proceed against that person by way of what? Contempt of court. You start instituting contempt proceedings against the person. A judgment may also be declaratory, but in that declaratory judgment, like I have said earlier, it will also restrain the defendant from further act of trespass into your land, perpetual injunction at that level, at that stage, the court grants perpetual injunction against the defendant because that's the final determination. If the defendant, for any reason, disobeys that part of the judgment of the court and continues his act of a trespass or re-enters into your land again, you don't need to sue him. You can pursue your second remedy as a judgment creditor, and that is what? To institute contempt proceedings against that very person. Then the third remedy, which falls within the executor enforceable judgment, will be to pursue what is called garnishee proceedings. Garnishee proceedings. If, for instance, you have been adjudged for a particular sum of money to be paid to you by the opposing party, the other party, the adverse party. So if there's no appeal against it, you can pursue against that party by trying to do what? Caveat his account. All you need to do is get to know his bankers, which bank he banks. You file an action, the garnishee proceedings, making that bank a party. Then get the order. The first order you're going to get there is an order ex parte. So that order ex parte gives you the court makes the order for garnishee nisi. So with that garnishee nisi, the bank will come to show whether they have reasons not to release the money of the judgment debtor in their custody, or to even say that they don't have money of the judgment creditor in their custody, or to say there is a subsisting prior claim over the money of the judgment debtor in their custody. But in the absence of that, if the court is satisfied that the defendant has money in that very account and that money can satisfy the judgment debt or part of the judgment debt, the court may eventually make the order absolute, so that when the order becomes absolute, you as the judgment creditor can now get your money directly from the bank. Directly from the bank. So that is the garnishee proceedings. I don't want to go too much into details about that now. And then there is also the process of executing judgment on immovables. If, for instance, the judgment debtor cannot pay you, you can invoke the process of the court, which in the eyes of the law is like a fresh process, but it's not an institution of an action. It's just right, it's just like an application for a writ of fife, so that the writ of fife will now issue and signed by the judge to attach on the movable properties of the judgment debtor. Let's say the judgment debtor has a car. So you can the judgment can be executed, levied against the car of that person. The car will be impounded, taken to the court premises, and that if there is no application from the other side, from the judgment debtor, and there is no reason why the vehicle cannot be sold for the money to be given to the judgment creditor, then the vehicle will be sold. Then, if, for instance, in trying to execute the judgment, you can't find this person's account number, you don't know the bank, maybe the person doesn't even have account number, and he doesn't have a vehicle, he only has a house. So the laws provide that you must first of all make attempt and show the court that you have made an attempt to levy execution on the movables of this judgment debtor, and that since you have failed, you are now asking the court for a writ of possession to issue to attach to the property of this judgment debtor, so that that property, the immovable property, could be attached in the execution of the judgment delivered against him. Now, again, there's something called receivership. Receivership is also another remedy for a judgment creditor. Now, this operates in two ways. I'm sure you may study that in your company law. Receivership operates in two modes. First of all, there is a receivership that, assuming the judgment debtor here now is a company. I'll also talk about when the judgment debtor is not a company. If the judgment debtor is a company, then, and you've gotten a judgment that you cannot levy execution in any other way except by way of receivership. Now, the first mode of receivership is the receivership against a company that is still in operation, a company that is still carrying out its operation. The idea of this very mode of execution of judgment is that it only entitles you to sack the management of the company, take over the company until you are able to recover your money. And then there is also receivership against a company under liquidation. In that case, the company has already died, but it still has properties that may be sold and then apportioned to the creditors of the company. So you are now coming in as one of the creditors of the company. So receivership under that very umbrella is also recognized under the law. Then again, too, there is nothing stopping any person from seeking to have the registrar of the court appointed as a receiver in respect of a particular property, in respect of a particular, maybe, let's say, business enterprise where you know your money will come out from. That's one other way of enforcing it. And then we also look at what you have learned in your law. That's the Mareva injunction. If at a particular point in time when the action is going on, and you have reasons to believe that this person you have sued, if judgment is given against him, that the only way you can recover is by the property the person owns within the jurisdiction. So you can go for Mareva injunction for the court to restrain him or restrain the company from removing the property from the jurisdiction. So the property will remain there. The property can also be moved and put into the custody of the court. So that by the time you get your judgment, that property serves as a collateral. It will be easier for you to do what? To levy execution on that very property. That can be done in terms of money. It can be done in terms of property that could be sold. Remember the case of Arlene Jet is one of those cases on Mareva injunction. So these are remedies that are opened to a judgment creditor who has secured a judgment, so you can explore any of these modes that we have talked about, any of these remedies, in order to ensure that the judgment that he has obtained is not mere pyrrhic judgment, so that he will be able to enjoy the fruits of the judgment that has been delivered in his favor. So thank you very much. At the next lecture, we'll be looking at the remedies of the judgment debtor.